So what happens if you have kids and you're doing estate planning? How do your children factor in to the planning? I'm Freeman Green with Freeman Green Law. Let's take a look at how to plan for children. When we're doing estate planning and you have kids, I think there's kind of 4 general things you want to think about including in your estate plan. First, and probably the most important, is you want to make sure to have a guardian nominated in your estate planning documents. In other words, if something's happened to you and you can no longer serve as the parent for your children, who will be the parent or the guardian to take responsibility for your children? And that guardian role is going to involve things like seeing that they get to school, seeing that they have a safe place to live, helping them with homework, things of that nature. All those things that we would think of as being parental in nature. This would be the person to make sure that they get proper medical care and dental care. So the guardian role is very important. To nominate a guardian, you want to do a document that specifically states who you want to serve as guardian. And you'll see different attorneys do this differently. A very common approach, and the approach that I take, is to build into a person's will the guardian provisions. The reason I like to do it in the will is because of all of the estate planning documents, the will is the strongest document from a witnessing standpoint. Most estate planning documents require a notary or perhaps 2 witnesses, but a will requires 2 witnesses and a separate notary in most cases. And so building those guardian provisions into the will makes those provisions very strong, very defensible, and often my clients tell me that the planning for their children is the most important to them. So guardian provisions in the will, although they can be built into other documents. So a few comments about guardianship and how the appointing of a guardian works. You'll note that I used the term nominating a guardian in your documents, and that's what you do. In the will, or if you're using a different document in that document, what you'll do is you will nominate a guardian. You'll also typically nominate a backup guardian. Now, the reason I use the word nominate is you naming a guardian doesn't in fact put a guardian in place. The way that it works is that if a minor child's parent dies and there's no other parent there to take care of them, in order to get a guardian or a new parent in place, it takes a court action for that to happen. And that court proceeding is known as a guardianship. In a guardianship, one of the things that will happen early on in the guardianship is if there is written evidence stating who you want to serve as the child's guardian, that written evidence will get filed with the court, and it will serve as strong evidence of who should be appointed as your child's guardian. So sometimes folks will ask, is there a way to avoid court involvement when it comes to guardianship? And the answer is there isn't, at least not in Oregon. The law takes very seriously who would be the parent of a child if a parent has died. And so that is something that will get reviewed and approved by a probate court through a formal guardianship process. So we've nominated the guardian. Once we've taken care of that, we need to figure out what happens if they inherit. Most of the time, young children and even young adult children aren't well suited to receive a large inheritance and manage it responsibly. So you can build provisions into your will or into your trust that state that their inheritance will go into a bucket or a trust. And there will be a trustee that's in charge of that trust or that bucket that's holding their assets. And that trustee's job will be to see that those assets are properly invested, managed, and handled, and for distributions to be made, that trustee is the one to make the distributions. So, for example, if the beneficiary child comes to the trustee and says, I really need a distribution so that I can buy a Lamborghini, the trustee would probably say, no, we're not going to make a distribution for that. But the trustee could say, I see that you need a car to handle the internship that you have. And so the trust will help you with purchasing a reasonably priced vehicle that you can use. So the trustee is kind of the manager and the gatekeeper of a beneficiary's trust. And these trusts can be designed many different ways. It's something that your attorney will talk with you about in some detail when your estate plan is designed. Often there's an age set, and the trust will terminate when the beneficiary reaches age 30 or age 35, whatever age you choose. And at that point, the distribution will be made to the beneficiary, and they will then just do whatever they want with the inheritance without a trustee's oversight. Or these can be made to last for a beneficiary's entire lifetime, depending on the circumstances. So once we've planned for managing the inheritance, one thing that we want to think about is if you have children that have reached the age of 18 and perhaps they're going away to college or they're now living on their own, they ought to think about doing their own very simple estate plan. And oftentimes what parents will do is the parents will go ahead and pay for a very simple estate plan for their child. Because if something happens to the child, it's the parent that's going to step in and handle the mess. What are the documents that would make up a very simple estate plan for a young adult child? First, that young adult child, we'd want them to sign something called a durable power of attorney. Oftentimes this would name the parent and give the parent legal authority to take action with regard to the financial matters and financial affairs of that young adult child. So if that child is studying abroad and something happens to them and financial matters need to be dealt with here, while that child is incapacitated or unable to handle those matters, the parent can use this document to handle those things. Similar to the power of attorney is the advance directive. That's what we call it here in Oregon. The advance directive is like a power of attorney, but specifically over medical decisions. Very important document to have. If something happens to your young adult child and they're in the hospital, you want to be authorized to perhaps make medical decisions for that child if they're unconscious or if they can't make decisions for themselves. This document will allow for that to happen. Two very simple documents that can really save a lot of headache if something happens to a young adult child. Then a final thing that I encourage parents to do, and this is by no means required, but I think for many folks they would be well served to do this, and that is to write a letter to your children. And the letter can be about anything you want it to be, but you can think of it like this. If you have written a letter to your children, you have control over what your final words to your children are. And that's a powerful thing. I'd encourage everyone, if you've got children, to write them a final letter, seal it in an envelope, put it with your estate planning documents, and if something happens to you, you'll be able to give them final words of love, wisdom, maybe some humor, and that will be something that they will treasure and that will be meaningful to them for the rest of their lives. So, when it comes to thinking about how kids factor into the estate planning, those are some key principles. Make sure that you've got the guardian. Make sure that we've managed the inheritance. Make sure that if your child has reached age 18, that they're starting to think about their own estate planning documents. And consider writing a final letter to your children. That is how we do estate planning when you have minor children. Thank you for watching. I hope that was helpful to you. If you think that video might be helpful to someone else, please feel free to share it with them. And if you think that our law office might be able to help you with trusts, probate, or estate planning, please feel free to contact us. Thank you.